am Megan Hill from the Harvard Project, and with me today is Del Laverdure, a citizen of the Apsalika Nation. He's an incredible leader throughout Indian country. He's an attorney, among many other roles, was the former acting assistant secretary overseeing the BIA. So Del, last night there was a really important ruling related to the CARES Act and Indian country. And I wonder if you might comment on what U.S. District Judge Mehta said. I also know that you've been in touch with other leaders since the ruling, and so I'm wondering how other tribal advocates are thinking about and summarizing the same ruling.
Thank you for having me, and thank you to the Harvard Project for posting these important updates and information on what's occurring in Indian country. First and foremost, I'd just like to send blessings and many prayers for those who are suffering in this pandemic and the fear and the not knowing what's going to happen in the future. And just want to send my thoughts out for everybody in Indian country in that respect to begin with. With respect to the court decision last night, yes, it was a very significant decision for a variety of reasons, but just to back up a little bit about what the case is about and give some context for any of the viewers. In the first two pieces of legislation for coronavirus relief, Indian country was largely left out. And so some of the available federal resources weren't getting to Indian country fast enough. Whether it was the equipment, testing, a variety of things. And I think people have seen through news reports, articles, social media, that the relief hasn't come as quickly as it could or should. And so because Indian country was left out, there was a delay in all of that, in all those resources getting to tribal peoples. So in the third act of Congress, called the CARES Act, there was a specific set aside for Indian country, which included a totality of $11 billion. Part of that went to IHS, the Indian Health Service, part of it went to the Bureau of Indian Affairs. There were some other pots of money here and there, but the large part of it was $8 billion that was set aside from the state and local government total fund that Congress authorized and was going to appropriate. Out of that $150 billion, $8 billion was set aside for Indian country. That kind of sets the stage for the case and the decision that occurred last night, which was about the definition of tribal governments and who was eligible for the $8 billion coronavirus relief fund. There were a number of limitations put on that fund, but the focus of the case really was on what is the definition of tribal government and whether in specific Alaska Native corporations were eligible for that fund. And after a series of lawsuits preceding that, starting from roughly April 17th, there were 3 separate lawsuits involved, and all of them asked for a temporary restraining order and a preliminary injunction to prevent the Secretary of Treasury from distributing the funds until this question was answered. And so there was a hearing held last Friday by the 3 sets of lawsuits, which were all consolidated. And then the hearing was held by Judge Mehta in DC last Friday, April 24th. The focus of the case really was on these on these definitions. And there was, before we even get into the final ruling, there was a set of legal standards that have to be met for what is a temporary restraining order and preliminary injunction. And the 4 of those factors that are considered by courts are irreparable harm, number 1, the likelihood of success on the merits. So if this were to proceed over the course of weeks or months, would the plaintiff still be able to prove, and would they likely have success? And then there's 2 other factors which actually got combined in this case. The third one was a balance of equities. So a judge has to look at what is equitable here on the parties involved in the case and what makes sense according to the statute and what is equitable. And then finally, is there public harm by issuing this preliminary relief. And the last two get combined when the federal government is involved for lots of other legal reasons. But so the focus of the case really came down to the first two factors that was argued by all the parties during the hearing. The long and short of it, in the conclusion, Judge Mehta said that the Alaska Native corporations were not tribes under Title V of the CARES Act, and also importantly included some references to the Indian Self-Determination Education Assistance Act, call it ISDEAA, and it's many people in Indian country probably know that Indian Health Service and BIA can do 638 contracts where tribes can take over certain functions of the federal government and perform them themselves under these contracts. And so under that definition, not to get into the weeds too much, but I think it really turned on, do the Alaska Native corporations meet the tests that are often required of tribal governments here in the lower 48, and they do in having a federally recognized body, and also fulfilling the requirements of the federally recognized tribes list act from the mid-90s. And in both cases, the judge said it doesn't appear that they do, and so that's why he granted the temporary relief. One other point that I think is really important is that this does not say and doesn't affect the Alaska Native villages themselves. The 229 federally recognized villages that are part of the definition of tribal governments, they are still eligible under this, even with the lawsuit. So it just focuses on the Alaska Native corporations themselves. In answer to your second question, outside of the case, what does this mean for Indian country and what are tribal leaders thinking going forward? There's some discussion among the tribal advocates across the country, and I think folks largely agree that there are likely three outcomes that come from this. The first one is that the United States Department of Treasury decides to appeal and say that Judge Mehta got it wrong, and there is conflicting precedent for some of this over in the Ninth Circuit, over in the western states, California, Alaska, that has allowed for Alaska Native corporations to be eligible for a variety of different federal programs. And so the question is, do they go forward on that and get clarification from the appeals court on that question? That's one possibility. The second possibility is that Department of Treasury just simply says, okay, we accept the ruling of the judge, and we will change our position on the Alaska Native corporations, and we will proceed to distribute the funds for coronavirus relief. And then finally, the third possible outcome is that maybe they just don't distribute at all or in part, and that they proceed with the litigation and then see where the finality of this appears for all. So, I mean, just to backtrack, you could have the United States could go forward, distribute the monies, say we agree with the decision. They could say, we're going to proceed with part of it and hold part of it back while we get this question answered about whether Alaska Native corporations may be included or not in the appeals court. Or they could simply hold all the money and proceed with litigation to get finality, and then decide how they're going to distribute all of the money. So you can see that a number of possible outcomes could occur. And as of our time of speaking here, I don't think there's been any update or indication on what that decision will be. And they have some time to decide, and I think they're going to take a little bit of time to decide on what their next steps are.
So given these outcome possibilities, do you have any sense on what the timing is? I mean, we know there's a huge need in Indian country. COVID cases on reservations are 4 times higher than the US as a whole. Any sense, any thoughts on that?
It's really unknown at this point, but it's important to remember that the statute that created the CARES Act, which was for coronavirus relief for tribal governments, the statutory deadline was 30 days when it was enacted, and that was March 27th. So April 26th would have been the distribution, and that falling on a Sunday, the United States, during consultation sessions, had expected to distribute the full fund this past Friday, April 24th, before these cases were filed. And then after these cases were filed and the hearing was pending, the United States took the position that they would wait to see what happened in the court decision and then distribute all of it today. Now, because of the nature of the decision that Alaska Native corporations were not eligible under the CARES Act, I think the United States has these set of options we discussed, and they could proceed with part of the funds in a matter of days, or they may withhold them pending probably the expedited remainder of the litigation going forward. So I think your guess is as good as ours. There's possibilities that it could happen quickly, and there's also the alternative, and it'll depend on what the United States decides to do.
Well, thanks, Del, for your time. I know you're incredibly busy. Do you have any last thoughts?
I think that a number of folks would have liked to have seen Treasury put out the formula that they're actually going to use to distribute, so tribes could maybe plan, work with their local banks or lenders and see if they couldn't cover costs of the tribal communities going forward, knowing that they would get a certain amount. The fact that that distribution formula hasn't been made public, I think, has also frustrated efforts for perhaps alternatives that tribes could be exercising. So I think a lot of people would like to see the updated guidance from the Treasury so that they can make plans and take care of their people as quickly as possible.
Super. Yeah, it'd be incredibly helpful if Treasury could release that formula so we could get prepared. Again, thank you so much. Incredibly useful information. We will absolutely share it widely with Indian Country. Thanks again, and take good care and keep safe, everyone. Thanks.